Welcome to Tax Sale Insiders, the latest from Tax Sale Resources, bringing you information about tax sales from experts in the industry. We recently interviewed Maureen Zink of Carlisle Law based in Cleveland, Ohio. She has practiced law focused around tax distressed properties for over a decade and shares her wealth of knowledge concerning tax certificates in the great state of Ohio. So sit back and relax for another episode of Tax Sale Insiders, powered by Tax Sale Resources.
Hi, everyone. Welcome to another episode of Tax Sale Insiders. I'm Brian Seidensticker, CEO of Tax Sale Resources, and I have a special guest with me today, Maureen Zink, attorney from Carlisle Law here in Cleveland, Ohio. My favorite question, honestly, to ask everyone is how did you get in this industry? Because I doubt most people grow up with aspirations of becoming a tax sale attorney or anything related to tax sales. So just fill us in a little bit on how you got into this industry.
Sure. So it'll be a story probably familiar with a lot of your viewers. I graduated law school in 2008, which was right during the last big recession. So dreams of going into many fields of law were kind of put on hold because during recession, certain areas aren't really hiring. But the areas that were booming at that point were foreclosure and bankruptcy. So I was happy to at least be able to get a position, and I basically started practicing in bankruptcy for a couple of years, which was a great foundation, a nice starting point. So I did that for a few years, and then I relocated to Cleveland and basically got hired at a law firm who they specialize in just tax certificate foreclosures, which is a little rare because most attorneys, at least in Ohio, will do both mortgage foreclosure and tax certificate foreclosure. But this firm just solely did tax certificate foreclosure. So I unknowingly entered the tax certificate world and got a crash course because if that's all that you do, you become very specialized. So I was there for several years. That's where I really got some great exposure, great experience, several different clients. And then I moved to the firm I'm with now, Carlisle Law, and I've been here for about 7 years. And so now I do both, again, mortgage foreclosure and tax certificate foreclosure, but I've got that specialization in tax certificates.
Got it. So you're go where the business leads you as you come out of law school.
Correct. It was a bit of a happy accident. You have to go into the areas that are hiring at the time. And so, things are cyclical. So we're back into a time now where these areas are back in the growth track. It's been interesting for sure. When I graduated from law school, I certainly didn't foresee where I'd be now, but definitely happy where I'm at.
Yeah, that's pretty common. What you mentioned, you're a transplant in Cleveland, like myself. I guess where do you come from?
I'm actually from the southern suburbs of Cleveland, but
Okay.
I spent a little bit of time moving around Ohio for school and grad school and whatnot. So I was happy to be able to come back to the Cleveland area, and I've been here now, back in Cleveland for about almost 10 years now. So it's nice to be back near family.
Yep. Yeah, family is pretty important, isn't it?
Mm-hmm. Yep.
Well, it's all right. Well, I guess we'll dive right into the nitty gritty details of Ohio. It's got some interesting nuances. You wrote an excellent white paper here. I did do my homework, believe it or not. It focuses a little bit. It's called Ohio Tax Certificates. It focuses mostly on the foreclosure process, but I know that's not all that attorneys are involved with here in Ohio. And so I'm going to dive more into the pre foreclosure stage first. But I guess the real basic question is, I guess, do you consider Ohio a tax lien state or a tax deed state or a hybrid, or I guess what do you consider it?
I would consider it a tax lien state.
Okay.
Because you buy liens, and then if they don't redeem, then you take them through the foreclosure process. In the end, your ultimate goal is usually to get a redemption and get your investment back, or to get a deed to the property. So I would call it a tax lien state because you have to take it through the course and basically reduce it to a judgment and then potentially a deed.
Okay. Now I know they have, they may call them sheriff sales here in Ohio, and that's just part of the foreclosure process, like a mortgage foreclosure then. Is that accurate?
Correct. Yes.
Okay.
So in Ohio, 2016 started to allow private selling officers who act just like a sheriff. Essentially, they're a licensed real estate auctioneer. So now we've got the legislation in place for that.
Okay. So they now have two, as of what year? 2016?
It was 2016.
Okay. So they have two different, I'll say, offices or abilities is to offer it. One through the sheriff sale, which is the traditional route, and this new one, which is what would you call it again?
Sure, it's a private selling officer.
Private selling, PSO. Okay.
Yep.
Right. Okay. Interesting. And now is that PSO route used often? And I apologize, I'm getting probably a little ahead of myself, but since we've started down this rabbit hole, let's go a little further. So is that used on a large scale, or is that fairly unknown? I guess what's the current status of that?
At the beginning, it wasn't being utilized very often. I think it's definitely grown in popularity. So typically it's based on our client directives. So we've had some clients that are very much in favor of a private selling officer, other clients that are still preferring a traditional sheriff. So in both situations, the sheriff still has to appraise the property. It's just a matter of who's actually going to sell it. A lot of private selling officers do their sales online. They can also conduct it at the property if they choose, but most of them are doing them online. So you're looking at possibly getting a different group of purchasers. So some clients are actually saying it's property dependent. So certain properties they want to go private selling officer, others they're fine with going a traditional sheriff sale. The impetus behind the legislation was that there were some significant delays in getting properties sold. We're not really seeing those issues now, and we haven't been for maybe the last year or two. But it's nice to have the alternative. Now it is based on motion, so you do have to motion the court to appoint a private selling officer. So some courts have not been happy about private selling officers selling property over the sheriff. So there's still some courts that will not grant a motion to appoint a private selling officer. So It's kind of important to know what type of county you're in, and sometimes it's even based on the judge, not even the county. It could just be that particular judge doesn't like private selling officers. So, but yeah, definitely growing in popularity, and new private selling officers, they have to meet licensing requirements, seem to be popping up. So we'll see where that goes.
So these PSOs are, auction houses or auctioneers that are licensed in the state to perform these services. For some of our audience, they're actually prefer to buy the property, and so they may attend the sheriff sales. Currently, I guess how does one go about finding out when, where, what properties are in these privately held auctions?
Sure. So both private selling officer and the sheriff have to advertise the property for 3 consecutive weeks. So either the county sheriff's website should have the property information posted, which should include an appraisal, typically what the opening bid will be, which is usually in a sheriff's sale, the first sale at 2/3 of the appraised value, and then any terms of the sale or steps they need to take. The private selling officer will do very similar things. They've got to post that information on their website. And in addition, the plaintiff or whoever's selling the property in that case has to file a notice of sale and will typically indicate where that's going to be held. So when it's a private selling officer, it should include their website or information about how you can get to that website. So that, and probably a relatively simple Google search of the private selling officer name. If you're savvy enough to look at the docket and see the motion and entry appointing the private selling officer, the information might be in that motion, and might also allow you to find at least the name of the private selling officer and direct you that way. But it's definitely a great resource, especially if there's buyers that are out of state or don't want to drive to a courthouse in the middle of nowhere to buy a property.
That's not the typical vacation destination anyway. Go
No.
attend a tax sale at a courthouse. All right, I'll bring us back a little bit because that's all part of the foreclosure process. So I'm going to go back to the basics. So I know Ohio has a pretty unique sale structure. I'll call it a bulk sale, where the county really sells all the liens that they have. But I know there's a selection process. I know there's maybe a proof of funds required, et cetera. So help me understand, or help us understand how that process works.
Sure. So back in 1998, Ohio introduced legislature which allowed each county treasurer to decide on their own if they wanted to sell tax certificates, which consist of pass-through real estate taxes, as a way to garner some revenue for the county. So Ohio's got 88 counties, a little over half currently sell. So the legislation's in place to allow them to sell. It's just up to the individual treasurer. So that number, certainly can change. There are counties that have sold in the past and have decided not to sell anymore, and there's counties that have never sold that may choose to do so in the future. So of the about half of those counties that do sell, the treasurer, under the statute in Ohio, gets to choose what type of sale to conduct. So I'll give you the code reference is revised code 5721.32, and that's a bulk sale, which is a traditional auction. And then the code section 0.33 is a negotiated sale. So if you like, I can kind of touch on both separately.
Yeah, I didn't even realize there was two different types. So yeah, dive into it. Absolutely.
Okay, so the bulk sale, which I'll just caption this with saying there's only one county right now that still does this, and that's Hamilton County, which is Cincinnati, for those non-Ohioans. So the bulk sale is the traditional auction where you show up in person. They release a list in advance. You can do your due diligence as far as looking at properties or however you want to do that. Basically, you show up. You start at 18%, which is a statutory maximum on a tax certificate in Ohio, and then you bid down in 1/4% amount. So basically, you go from 18%. If it's competitive bidding, you can go all the way down to a 0.25%, which is the lowest bid.
Okay.
And it's been fairly competitive in the last couple of years. So I think for at least the last few years, there's been a multiple way tie. The statute doesn't indicate how that's to be handled. So from what I've heard, and I've never actually attended one of these in person, it's come down to drawing business cards out of a hat. So,
yes. Oh, I love this industry.
So, correct. And typically, you don't get to choose which properties you're buying. It's a list. So, you're going to buy those properties or not. It's really just the interest rate. So the last couple of years, it's gone all the way down to the 0.25% and been a tiebreaker. And then the winner is either the lowest interest rate or the business card pulled out of a hat, or whatever mechanism the county chooses to use.
So now they're not doing this on individual liens. Here's a list. What is your lowest acceptable bid on the whole package, right?
Correct. Yes.
And that the purchase price, I guess, would be the face amount or the total taxes due on each of those liens. Correct. The sum. Okay.
Yes.
Interesting. Okay. Now, how does the other process work? The negotiated sale.
Sure. So negotiated sale is become the preferred method of Ohio County treasurers. The statute in Ohio gives the pretty much latitude to do almost whatever they want in regards to the terms. So in a negotiated sale, typically the county releases a list of properties and says, here's a list of properties. So some counties send out more of a curated list. Other counties, it's a kitchen sink approach is what I call it. And they'll send you a list of every lien that they have that's eligible to sell. And then basically you need to, in theory, do your due diligence, review that list, and then come up with a list of properties that you would, you want to purchase, meaning pay the amount of taxes that are currently due. And also some counties will set the interest rate for the negotiated sale. other counties won't, and then that's a negotiating point. So you're going to be
Okay.
selecting the properties. For most counties, you're going to be selecting the interest rate at which you want to submit your bid. And then many of them also kind of have an RFP or a questionnaire where they want to know about your company, about perhaps your servicing, that sort of thing. So it's more of a whole thing. And basically you submit your bid as like a sealed bid, and it goes to the county, and then they review all their bids, and then they make their decision. Some counties, like I know Cuyahoga County releases kind of a grading rubric for, this is how we want, this is the information we want, this is how we're going to make our decision. Other counties seem to be a little more informal, and they'll ask for certain items, and then they'll review it, and then they will announce who's won the bid. So most counties in Ohio, heavy bidding is in the fall. So obviously I don't know about this fall due to the pandemic, but in normal times it's usually in the fall. And some counties sell every year. Other counties will enter into multi-year purchases. So, but yeah, the negotiated sale is a little bit more of a lengthy bid process.
Okay, but in both, well, I guess the bulk sale you're saying is actually in person. So the negotiated sale, there's not an actual sale day or date per se. It's a lengthy process, not, or I guess to say very close to an RFP or a proposal process where, they probably have a deadline, I'm assuming, when you have to have them in. Is that the sale date? Is that what they consider the sale date? And then they have a time period where they make that decision. Is that decision a quick one? Does it take weeks, months? What does that look like?
It's really dependent county by county. So some counties, it could be days. Typically it's not too long because, people have submitted these proposals, and it's going to affect other business decisions they're making. Mm-hmm. So I think they try to take that into consideration. But really it's dependent on the county, and, typically they'll contact the participants. So sometimes it can be hard to find out immediately who won the bid.
Got it. Okay. So I guess the short answer would be every county's process is slightly different. There's not a standardized process across the state. You mentioned only half of the counties in Ohio actually utilize the tax lien sale process. What does the other half do? Do they not do anything? Do they, I guess, hold it on their books and only do the sheriff sale or the PSO route? I guess what does the other half of the state do?
It seems like the other remaining treasurers either have very low delinquency rates, which is a nice problem to have, or they utilize their county prosecutor to prosecute delinquent tax cases, as opposed to selling it to a private certificate holder who would then essentially step into that role. Okay,
and so they still have the same to sale process. So it's more like a tax deed process where they foreclose on the county forecloses on the property instead of allowing the certificate sale or certificate holder to foreclose on the property. Is that accurate?
Correct. Yeah. So the county prosecutor would prosecute on behalf of the county, and then in theory, if it gets to a sale, they would offer that property at a county tax sale. Okay.
Interesting. Now I know, since pretty much every county that has sales is done in bulk, you obviously need, fairly decent capital to participate in these sales. Is there any sort of requirement? Do you have to show a proof of funds? Do you have to be a registered entity in Ohio? Is there any requirements for participating in those sales?
Yes. So under both the public auction and the negotiated sale, the statute allows the county treasurer to ask for a proof of funds, like a letter of financing, to confirm. If you're going to be at Hamilton County doing the public auction, under the statute, you have to register as a bidder. I believe there's a $500 registration fee. If you're going to be in a negotiated sale, typically that's going to be one of the items requested by the treasurer. They want to make sure that you're a viable entity and that you can afford to buy their tax certificates. And then also, typically, once your purchase is completed, obviously you have to come up with the money to complete the sale.
Okay, but how, I know it probably varies, but what is like the low and the high end as far as the dollar amount that these sales total?
It's really county dependent. I mean, there could be county treasurers who maybe want to sell 10 liens, and that could
Sure.
be, you know,
Okay.
under 50,000. And then there's larger counties, you know, Summit, Cuyahoga, and those sales can go, you know, anywhere from 10 million plus. I think a couple of years ago, Cuyahoga was in the 30 million range.
Okay.
And the last couple of years, I think it's been smaller than that. I want to say the last sale was around 12 to 14 million.
Okay.
So it's very dependent on the county. But typically the beginning of the sale process, especially in negotiated sales, when they release those lists of properties that are potential properties, and then it'll list, you know, the tax amount. So you should know right off the bat the amount of the tax sale, and it's kind of a moving target because homeowners can redeem at any point. So usually what they'll do is they'll release their initial list, and then they'll release updated lists as you get closer to the sale, and they'll take off any properties that have redeemed. So
Okay.
it's definitely a moving target for anybody.
Yeah. Well, it's entirely dependent on what the treasurer chooses, right? So there's no requirement they have to sell every eligible lien. They can choose to sell 10 if they want. And so I guess depending on the year or the list, you might have a list that, like you said, is 100,000, you know, one sale, and the next year they may choose to do everything, and all of a sudden it's $3 million sale. So it really can vary widely. Is that correct?
That's correct.
Okay.
Yes.
Interesting.
Yes.
Okay. And now you mentioned you know, the bids that go from 18% is the maximum down to 0.25 or 1/4%. Are you not allowed to bid zero?
I believe 0.25, because it's in the quarter increments, is the lowest that the auction allows. I've never heard of a 0% bid. It usually just goes to the 0.25. But no, I think I think it's just because it's the way the statute's written. It's 1/4%.
Got it. Okay. And then and that's the yearly interest, simple interest rate you're going to earn on that certificate, whatever you bid, correct?
Correct.
Is there any other? I know, like Florida has an automatic 5% penalty, and some other states have that. Does Ohio have anything like that, or is it just the flat percentage that you bid?
They do. So if you purchase your certificates under the Hamilton County model, so 5721.32, then the statute does allow for an actual rate of 6%. So that probably makes sense as to why people are bidding at a 0.25% rate. So you can, essentially there's a redemption rate actually of 6%, but that's only applicable under that public auction, so 5721.32. So if you're engaged in a negotiated sale under 5721.33, that 6% is not applicable. So typically when you're submitting your bids on negotiated sales, you know, we're seeing more competitive interest rates, you know, anywhere from 12, 13, 14%.
Okay.
Yeah.
So that only holds in the bulk auction, which right now Hamilton County, Cincinnati is the only one that uses that, where that 6% is automatic. Everywhere else, if you are participating in a negotiated sale and you throw in a bid of a 1/4%, you know, you probably will win, but you're not going to get that 6%. Is that accurate?
Your business model might be flawed there.
Yeah. Yeah. Well, you know, everyone's got creative ways to make it work that I've stopped understanding years ago. But it's definitely something that would be a big oops if you didn't know that little nuance.
Yes, definitely.
Okay, so we have a pretty good understanding of how the sales happen. Now let's move into like the redemption process. I guess, how long does that take? Are there noticing requirements? Who's responsible for doing the servicing, or is it all done through the county? Can you go dive into that a little bit for us?
Sure. So in Ohio, it's a 1-year redemption period. So you purchase your certificates, you have to wait 1 year, and so 1 year and a day after that, you can start the process if you choose to foreclose your lien. And in Ohio, by statute, certificates are anywhere from a minimum of 3 years to a maximum of 6 years. So between 3 and 6 years, it seems what I'm seeing with a lot of counties, there are a lot of 3-year certificates. Every now and then you'll see a 4-year certificate, and occasionally you'll see 6-year certificates.
And that's the expiration of the certificate?
Correct. That's the life of the certificate.
Okay, so it varies depending on what the county decides is going to be that time. So at least 3 years and up to 6, but you could have a 3-year certificate 1 year and then they decide to assign a 6-year certificate the next year?
Correct. So it's up to the county treasurer, and it's always going to be on the face of the certificate.
Okay.
So if you're, in the secondary market and you're looking at a certificate, it should always say right on the face of the certificate, the life of the certificate, as well as the date it's issued.
Okay. And you have to start the process of foreclosure before that expiration.
Correct. So in order to file a valid foreclosure case, your certificate has to still have some life left to it. It can't be expired.
Okay. So you don't have to be complete with the foreclosure process, but at least has to be started.
Correct.
Okay. Does anything change once you start that foreclosure process? Does the interest rate still stay the same rate you bid it, or does any of that change?
It's a good question. So in Ohio, I'll backtrack a little bit. You get your certificate, you wait your 1-year period of redemption. If the homeowner has not yet redeemed, then a year and a day, you can go to the county treasurer and say, I would like to start my foreclosure process. I need to get my notice of intent to foreclose. So essentially, you have to pay any current taxes that are owed to the county. So during your 1-year redemption time, every now and then the homeowner does pay them, but for the most part, that's not the case. So you have to pay any remaining taxes at that point. Now you do.
Now is that all taxes prior to the lien you purchased and post? Is it just post? Is there any nuance to that?
It would just be post because.
Okay, so any taxes due prior to that lien being issued, the foreclosure process doesn't require you to pay those. Okay, I'll call them back taxes.
Well, typically your tax certificate is already going to encompass those.
Okay, so when they sell a certificate, they should encompass all prior years,
Yeah.
And then the foreclosure process covers all post years.
Correct. Yeah. So
Okay.
your notice of intent is probably just going to be that 1 year, but you can wait. I mean, if you want to wait, 2.5 years, if you have a 3-year certificate, then you would have to pay 2.5 years of taxes that haven't been paid possibly. So you go to the county treasurer, you say, I'd like to get my notice of intent to foreclose. They tell you the amount of taxes that are currently due and owing. Also, when you go to get your notice of intent, you do have to buy out any prior tax certificates that were issued perhaps to another purchaser on that property. So I don't know how often that happens. I haven't seen it happen very often. Usually I think the counties try to keep an eye on what they've sold, but it's provided for in the code, so I'm sure it does happen.
Okay, so I'm going to throw out a scenario here. If you have a 6-year certificate and you buy it and you choose not to foreclose after the first year, do you have the right to buy the subsequent taxes, or do they hold a different sale and you've got to buy it every year? How do the trailing taxes or certificates, how does that work?
Sure. So in Ohio, typically your original certificate is called your base certificate, and then your subsequent certificates are your subs. So as most counties do the negotiated sale, an important part of that's your negotiated sales agreement. Mm-hmm. So those are the terms, it's the contract you get with the county. So it's really important to pay a lot of attention to those terms because they're usually going to cover the purchase of subs. So the county could require a purchase of subs. Okay. They could say it's up to you. They could give you the right of first refusal and then offer them elsewhere. So that's an important term to keep an eye on, when you're looking at this. Okay. So typically purchasers will purchase a base and then 1, perhaps 2 rounds of subs.
Now, the subs at the same interest rate as that base, or are they at the statutory 18, or is there any difference there?
Any sub certificates at the statutory 18%. So
okay.
That's always going to be 18% on the subs. And then any money also that you put out for your notice of intent is also going to garner interest at 18%.
Okay.
So, and the notice of intent's a very important part of the puzzle because that also is what allows your counsel to file a foreclosure on your behalf. So you have to have a notice of intent to foreclose to file a foreclosure. It has to be attached to the complaint, and they're time sensitive. So from the date it gets signed off and stamped by the county, you have 120 days from that date to file your foreclosure case.
Okay.
So if it does not, it expires, and that is not what you want to happen.
So if it expires, you can't foreclose. Basically.
There's actually a provision under the code that allows the expiration of the certificates. And some counties also, I haven't seen it lately, but you can, under negotiated sale, adjust that time length. So there was a county that did allow 180 days to a purchaser to file a foreclosure. I haven't seen that recently, but that is something that you could negotiate on.
Now, is all of that spelled out on the tax lien certificate, or is it part of a separate contract between the lien buyer or purchaser and the county? And really, what I'm alluding to, Maureen, is if a certificate is bought on the secondary market, how does that knowledge transfer with that certificate?
In regards to your time frame on the notice of intent?
Yeah. Yep. Exactly.
Okay. So yes, so that's typically in the negotiated sales agreement.
Okay.
So your secondary buyer, I would probably request a copy of that. Some counties are really good about putting that document on the treasurer's website. I know Cuyahoga County typically posts their current contract. Franklin County typically records it, and the treasurer will direct you to where it's recorded, and you can pull up a copy and read it. Other counties, you can ask for a copy of it. But it's a really important document because typically the notice of intent timeframe will be included in that.
So definitely request a copy of that, whether it's posted or not. Highly recommended to get a copy of it so you know all the other terms coming along with that certificate.
Correct, because typically also many of them cover the assignment or sale of tax certificates to a secondary purchaser.
Got it. Okay, interesting. I'm going to take a little step back to just the redemption period and if anything's required during that process. So between the time you purchase that package from the county and the notice of intent, is there any other notice requirements? Is there any other nuance in that time period required by the certificate holder?
So in Ohio, the treasurer is required to send out a pre-sale notice telling the homeowner, hey, we're going to sell your tax certificate or your taxes. And then there's a post-sale notice telling them, hey, we did sell your taxes.
Okay.
So I have seen in some negotiated sales agreements, counties who are shifting the post-sale notice to the purchaser.
Okay.
So it's a pre-sale and post-sale notice that is many times issued by the county, but that is something that the county could shift to the purchaser. So that's something to keep an eye out. Other than that, many certificate holders do choose to send out notices to help drum up some redemptions, but just the pre-sale, post-sale no required.
Okay, so both historically have been done by the county. Some counties are starting to put that post-sale notice requirement on the certificate holder, and those are the only two notices that are required by statute.
Correct.
Now, so during the redemption period itself, payments that come in, is that all handled by the county? Does that have to be handled by a servicing process the lien purchaser sets up? What's the requirement there?
So again, it's going to be really county dependent. So some counties will take on some of the servicing aspects for their certificate holder. Others will not, and it's completely on the certificate holder for that. So it's really going to depend on your county as far as if the treasurer will be accepting, the redemption payments. Most will accept them on the certificate holder's behalf, and then also allow payments to the certificate holder. Some prefer just to go to the treasurer. So it's important to know what your county prefers or requires in terms of, do they want to accept only the redemptions? Do they want you to accept them? Is it a hybrid of both? And typically treasurers, under statute, it does allow them to set up a repayment plan once a certificate's been sold, but it has to be completed within the 1-year redemption. So the treasurer can enter into a repayment plan with the homeowner, but it's got to be completed before your redemption period concludes during the 1 year.
Okay, so they give you 1 year. You can't go beyond that 1 year, 1 day requirement. Can the certificate holder enter into payment programs as well?
As long as it's in in alliance with your negotiated sales agreement. So that's another term that the county treasurer could. And lately, I've been seeing more choose to put rules in about that. So they'll say, you can set up a repayment plan, but it has to be concluded in 12 months, 24 months, 32 months. It'll put some requirements on that.
Okay.
So that's another term, I guess, that's become a lot more visible.
Okay. So it sounds like every county kind of has their own, they have a lot of leeway of what they're allowed to do within pretty vague statutes. Would that be accurate?
Correct. So you can kind of see why they've mostly shifted to the negotiated sale. It gives them a lot more bargaining power. And because the market in Ohio seems to have gotten a lot more competitive in the last couple of years, it gives them that opportunity. They're not going out and looking for bidders. The bidders are coming to them, and the county's being able to dictate more terms.
Yeah, supply and demand has shifted in Ohio dramatically.
Very much.
All right. So you mentioned the cost associated with that notice of intent. I'm fast forwarding a little bit here. Sorry to jump around, everybody, but we're covering lots of ground. The cost associated with filing that notice of intent also earn that 18%. Is that notice of intent? Is that something that certificate holders have to do themselves, or they can? Is that something that attorneys can do or manage for them? I guess, how does that work?
Sure. So I've got several tax certificate clients currently, and so that's something that if our client wishes that we handle for them, we do. So it's essentially my client telling me I want to move on these properties. I request that information from the county. There's different response times for each county, of course. So you get your notice of intent amounts, and then notice of intent itself is actually a piece of paper, basically with information on it regards to the tax certificates, the amounts that's due for the NOI, and then under the statute it has to be signed by either the certificate holder or a private attorney that's active and licensed to practice in Ohio.
Okay.
So typically we sign those on behalf of our clients, and then it goes to the county treasurer. They make sure the certificates are still outstanding, that the notice of intent, that there's enough funds have been received to cover that, and then they stamp it with a date, and then your 120-day clock starts running.
Okay. Is there any limitations to what that amount is? That dollar amount you can add as part of that NOI process? Is there any limitations to that, or is it whatever the cost is? It is what it is.
It's whatever the cost is, and
okay. Within reason, is there anything that has anything been rejected by counties that say no, this didn't cost you $50,000 to file a notice of intent?
Oh, I'm sorry. No, I thought you meant the amount the county could charge you. As I say, no, they can do whatever they want. No, so in terms of attorney fees?
Yes.
You're going? Okay. Yeah, so under the statute in Ohio, you're allowed to collect attorney fees that are both reasonable, and you can collect them up to $2,500 without a court order. So it's not necessarily a cap at $2,500, it's just that you can do it without a court order.
Okay, so they have a good reason if you go over $2,500, basically.
Correct, yeah. So it kind of gives us an idea of where we should be. And so for many years, we kind of mirrored the Fannie Mae rates, which back when they were, a little bit $1,700, this is many years ago, they've since been adjusted. Tax certificates were, around $1,900, $2,000. As the Fannie Mae rates have gone up, they're now a little above $3,000. The tax fees, haven't quite mirrored that, but they're getting closer to the $2,500 mark, which is pretty much in scale with the mortgage industry.
Okay.
So most, myself included, we do something called stage-based billing. So essentially, as you move the case through the process, your attorney fees increase because the amount of work you put in increase. A lot of counties are now putting that in their negotiated sales agreements to kind of, I assume it's to prevent front loading of attorney fees. So I don't get my file and charge $2,500 right away. I get my file, I prepare notice of intents, and then I basically earn my first stage of fees. So the county can actually put in their negotiated sales agreement and say, at your first stage, you can't be above 300. At your second stage, you can't be above, 500 total. So they can cap it. I have seen that in quite a few county agreements. So that's, something to also keep an eye on and make sure your counsel is in alignment with your negotiated sales agreement. You don't want to get caught not being in line with their stage-based billing. The negotiated sales agreement can also just, flat cap your attorney fees.
Okay.
That's something else to keep an eye on. And typically the costs of the action also are allowed to be included, but it's got to be reasonable, and that's another term that counties are putting in their negotiated sales agreements. So maybe they'll say, you can charge $50 for a notice, but not more. Or you can charge $100 as an administrative fee per year for a payment plan, but not more than that. So they're really starting to flesh out amounts, and it may not be in your negotiated sales agreement. It might just be something that the county historically has done. So that might be a good question to ask them. Do you have set fees for the servicing administration of your tax certificates?
So those fees don't all come, prior to or included in that NOI that you file. Do the fees that come after, are they also earning 18%, or is it just those initial fees that earn 18%?
Well, the attorney fees don't earn interest typically.
Just the court fees?
No, the court fees don't typically earn interest either.
Okay.
It's just
Sorry, I probably misheard you. I thought you'd mentioned, fees that also earn 18%.
Oh, sorry. Yeah. So the amount that you pay for your notice of intent to foreclose that goes to the county treasurer, that earns 18% interest.
Okay.
Yes.
Just that fee. Everything else is an expense does it get reimbursed?
So yeah, your fees and costs of your action can be taxed as costs to your foreclosure case. And that's not something that can happen in a mortgage foreclosure. So that's unique to a tax certificate foreclosure in Ohio. So typically as part of the foreclosure case, we will include in our judgment entry, or if that court requires a motion the court to tax attorney fees as costs. And that's where that amount will actually be included. And then if it goes all the way to a sale, the fee and cost amount, so the attorney fee and cost of the action, get included as part of the minimum bid.
Okay.
So if the third-party purchaser buys your property at sale, everything's going to be paid from that sale. And then typically it's also included in the redemption for the homeowner. So if a homeowner redeems or another party to the case redeems, the fees and costs of the action will also be included in that redemption.
Okay. So you will be reimbursed for it, assuming it redeems, but you won't earn any interest on those fees.
Correct.
Okay.
And if I'm going way down the road, but if it forfeits to you, meaning nobody buys it at the sale, then the fees and costs obviously will be paid by the certificate holder or whatever your arrangement is with your counsel.
Okay. Interesting. Okay. So you filed the NOI, right? You started the process. You have a clock, typically it's 120 days, but it can be negotiated. This negotiated sales agreement is an extremely important document, I'm learning. Okay, so you have that 20 days or longer, depending on it. If you don't start the foreclosure process prior to that, it expires and you're basically up a creek. You're out every dollar you've spent to that point, including the certificate amount.
Correct. So there's a statute provision that actually says they do expire. So that might be something to keep an eye on. It's a question of is it enforced by the county. So I counsel all my clients best practices to really keep an eye on that date, and you want to have your action commenced prior to that date.
Got it. And then, okay, so once that action is started, I guess, can you walk me through the actual attorney process or foreclosure process that occurs once that kicks off?
Sure. So the foreclosure is a civil action. So we file the case, we file it in the name of the certificate holder, attach tax certificates and that very important notice of intent to foreclose as exhibits. In Ohio, you're required to get title work in any foreclosure case. So to start your case, you get a preliminary judicial report. And that basically is a title report, and that's going to tell you who owns the property and who has any liens of record, because you have to name them as a party to the case and give them notice. So we name everyone on the title report. We send out, we file the case, we send out notice through the court to everyone. A big question we get is, what's the time frame for Ohio foreclosures? And my typical answer is about 9 to 12 months, but that's very dependent on your service. So if you've got just the owner and a spouse, and then you can serve them at the property, you can really cut your time frame down. So you're probably looking at maybe faster than 9 months. If you have a deceased owner and you have to name all the heirs and you don't know where they live, it could be months, and you're completing service by publication. So it really is dependent. But let's say we get service. Once you get service, you have to give every party, in that case, 28 days if they choose to file a written answer with the court. So once that 28-day answer period runs for every party in the case, you can move for judgment. And so some counties require a hearing for every motion for judgment. Some don't. Some counties in Ohio have electronic filing, and some are still on the paper dockets. So again, a little bit of a research into what type of county you're in. So once you get a judgment in the case, and this is for an uncontested, meaning nobody's opposing you. Once you get a judgment in the case, then you can order a sale. And so, as we mentioned, those two routes that are out there. So you can either ask the sheriff to appraise and sell the property, or you can say, Sheriff, please just appraise, and I'll have a private selling officer sell the property. And I'm presuming you already got the court to sign off on your motion to appoint a private selling officer that we already talked about. So either the private selling officer or the sheriff will then advertise the sale for 3 consecutive weeks, and hopefully you get a lot of bidders at your sale in either way. If it doesn't sell at your first sale, in Ohio, tax certificates have always had 2 sale dates, which has been nice. So it doesn't sell at your first sale, then it goes up to your second sale, which is typically about 2 weeks from your first sale date. So you're at your second sale. If nobody bids at your second sale, then it's going to forfeit back to the certificate holder, or whoever is the holder of the certificates at that time.
Okay.
So you could end up with some properties. And so I know I'm jumping down, but that's definitely a potential pitfall that you want to be aware of. You're going to need to have some type of REO strategy in mind, because you could end up with properties, and unfortunately there's no way to predict which ones you're going to get or how many you're going to have, unless you have a crystal ball and you can see.
Right. If for anybody that figures that out, they'll be well off for the rest of their life, right?
Exactly. Mm-hmm.
Now you'd mentioned at one point that at least that first sheriff sale, the opening bid, is not just the sum of all the fees and the interest, right? It's 2/3 of the assessed value. Did I hear that right?
Oh, actually, so in a tax sale, it's just going to be the amount of taxes that you owe. So it's going to be what's owed to the certificate holder, any taxes that accrued during your foreclosure case. So the county is, of course, going to get paid again. So certificate holder, your county, and then your attorney fees and costs of the action. So that is what's going to be your opening bid.
Okay, so the 2/3 was mortgage foreclosure, not tax.
Yeah.
Okay.
Yeah.
Got it. Okay, and then it's the same for the second sale as well?
Correct. Yeah.
Okay.
So you are hoping, obviously, that someone either buys it or that there's competitive bidding, and then perhaps the other lien holders will also be paid.
Okay. Now, is it safe to say currently the efficiency at those sales, meaning the amount of bidders and the amount of properties that sell in Ohio, is less than it is in very popular states like Florida?
It's a good question. I don't practice in Florida. I just get a little bit of exposure to it at the NTLA conferences, because it seems to be a popular state. But I think occasionally we go to sales on behalf of clients. So it seems like there's more third-party bidders in Ohio, and it's county dependent. If you're in a rural area versus a more densely populated area, and also the home values and where the market's at in that particular area. But we seem to be seeing an uptick in third-party purchasers. I don't know how the pandemic's going to affect attendance at in-person sales, or online sales, but it's definitely seems to be encouraging in terms of third-party purchasers.
Got it. Okay. Excellent. Now, the property owner can redeem at any time during this foreclosure process. It's just a moving target of how much they owe because of that interest rate, that not compounding, that 18% that's being accrued monthly, right? So, but they can redeem all the way up to the day of the auction or even the day of the second auction.
They can actually redeem up until the confirmation of your sale. So let's say a third-party purchaser buys the property at your first or second sale date. They pay their money to the PSO or the sheriff, and then the court has to confirm your sale to confirm that it's been held in accordance with the law and everything was proper. And so during that time period in Ohio, that can take anywhere from 15 to 30 days for a sale to be confirmed.
Okay.
So anytime during that period, a homeowner could redeem, and then essentially you have to vacate those sales because the homeowner has exercised their right of redemption.
Okay.
So, in either scenario, the certificate holder is going to be made whole, either by the redemption or a third-party purchaser. It just depends on who's going to end up with the property.
Okay. So even after the sale, they can redeem for, sounds like, depends on the county, but up to 30 days in some counties.
Correct.
Okay.
After the confirmation of the sale, they can certainly get counsel and try to file motions, but
Okay.
at that point it's done.
So if I were to kind of sum up the time it takes for the foreclosure process, right? You file a notice of intent, and they give you about 120 days. If you wait to the very last day, right, to start your foreclosure process, it's a minimum. It sounds like of about a 9-month process, up to several months later, just depending on how many people you have to notice, if the homeowner wants to fight it, right? All that extends the time period. And then after that whole process takes place, you can order a sale. How long does it typically take from the time you order a sale to the first sale occurs?
So it's a little county dependent, and depending on if you're using a PSO or sheriff, but they have to advertise for at least 3 consecutive weeks.
Okay.
So you're probably looking at around a 4 to 6 week turnaround.
Okay, that's for the first sale, and then the second sale typically occurs about 2 weeks later. So is it safe to say from the start of or from the time you file that notice of intent to the time that second sale occurs is anywhere between 12 and 18 months? Is that accurate?
Yes, yeah, I think so. And unfortunately, it's so county dependent and case dependent. There are certainly cases that can really fly through. But yeah, so many of the things are just take time, and the courts are the courts. So it's always a good idea to have a good understanding of which county you're in, so that there's no big surprises in terms of your timelines.
Got it. Okay. Now, I'm going to shift a little bit to title. It seems to be a hot topic with at least the properties you end up with. Are there any liens that survive the tax sale foreclosure? And I'm assuming mortgages don't, but are there any liens that do? Mechanics liens, municipal liens, IRS liens? Does any of that stick with the property, or does the foreclosure process wipe all of that out?
So you're right, that's always a question we get asked. And so under the code in Ohio, you get a free and clear title. It's an insurable title. If you're handled correctly. So that there is 2 caveats. So basically easements that run with the land won't be cleared from title, and also federal tax liens. They still have their 120-day right of redemption. So those are something to keep an eye out. I personally have not seen the federal government exercise that right of redemption, but they have that right. And so
they
that's,
can, right?
Yes. And also I know you had mentioned code violations. So that's something else you need to keep an eye on. Okay.
So the code violations, as in you didn't mow your lawn, and there's typically a fee for that. Those are still due after.
It's kind of an interesting area, and it's in Ohio. The building and housing is typically done on a municipal level, so it's on your city. So the county sells the tax certificates, and then you're going to deal with the city for building and housing. So 2 different entities. So you It also depends on, did they, give proper notice to the owner, the certificate holder at the time. So there's kind of many things included in it, but you definitely want to keep an eye on those code violations and the specific municipal statute that they're operating under, because there's definitely a chance that if people were properly noticed at the time, that you might be responsible for those. So unfortunately, that's not a great answer, but so it very much depends. But definitely something to look out for, and demolition notices are also something to keep an eye on. Nuisance abatement issues kind of abound.
Now, is there any requirement on a demo lien is probably the most potential hazardous, right? Is there any requirement for those demo notices to be sent to certificate holders as well, or do they have to try and monitor that separately?
It's not under the tax statute. It's again, probably, look under the municipal statute that they're operating under, who they're giving notice to. So the certificate holder is just a lien holder. They have a super priority lien, but you're a lien holder essentially. Mm-hmm. So you're not the owner of the property until you take the property by forfeiture. So that's where the noticing can be tough. If the city code says you just have to notice the owners as opposed to everyone that has an interest in the property, perhaps it's not a requirement that you get notice. They could give a courtesy notice. They may notice you by accident thinking you own the property when you don't yet or don't at all. But probably something you want to look into. And in Ohio, tax certificates are only in RAM, so there's no personal money judgment. Mm-hmm. So if your value is going to come from both the land and the structure, and your structure is in danger, that's something to keep an eye on if you're recouping your money.
Okay, so some municipalities may give you notice because it's either required of them or they just do it as a courtesy, but it's not required everywhere. So it's certainly something to monitor separately. They're not going to tell you themselves in all cases.
I know, I think it's City of Cleveland will record an affidavit. So that's a recorded document that you can find. Not on everything, but occasionally they'll record. So that's something that you might be able to look up. That's a public record. Other building and housing departments may have access to online database, or you unfortunately have to do the old-fashioned phone call or send an email. But yeah, something to keep an eye on for secondary market purchase.
Got it. Okay. Excellent. What happens to the liens, and maybe this doesn't happen ever because it's all negotiated or bulk sales. Are there ever any liens that don't sell from the county?
Yes.
What happens to those? Do they just put them in the next sale? Is there a separate foreclosure process that occurs, or do they just sit there forever?
It's a good question, and it's of course county dependent in Ohio. So the treasurer could choose to do like a secondary smaller sale. Maybe the primary purchaser only wanted half the liens, so maybe they try to get more revenue and do a second sale. Mm-hmm. They can also send those to their county prosecutor, so they basically would foreclose on them in-house, or they could just leave them for a future sale.
Okay, but in any of those cases, an individual investor can't go to the county and ask to purchase those by themselves. They'd have to go through the standard sale process if that were to occur.
Well, I would certainly encourage them to reach out to the county and see, would they be willing to sell any remaining, certificates that were not purchased. Okay. They may have a negotiated sale process, where there might still be vetting or whatnot, or perhaps, you entered the primary sale and you weren't the winning bidder, but maybe you've already been vetted. And so I, would certainly encourage anyone to reach out to that county treasurer and see if that's something they're willing to do. Okay,
so there's potential there. It just depends on the county and the person running the show, the treasurer. All right, are there any? Some states have a bunch of changes coming down the pipeline. Is there anything like that in Ohio where you foresee any either statute changes or process changes by counties that's becoming more common? Anything like that coming in the near future?
Not that we're aware of. The private selling officer was a bit of a change. Certainly not a bad change, just to give more options. But nothing in the foreseeable future. Really, the changes we're seeing and trying to stay on top of are the county treasurers, what they're focusing on, and those very important negotiated sales agreements. What areas are they really focusing in on for our clients, so that our clients obviously can remain competitive. And so really that's kind of where we're seeing the changes.
Okay. So it's fairly steady Eddie here in Ohio.
Hopefully, yeah.
Hopefully.
So, certainly legislation can change at any time. And the counties do have a lot of leeway in what they can do, how they can conduct their sales, their terms, and that sort of thing. So yeah, it's definitely it's always an area that's changing. But at this moment, I don't know of any legislative changes that are on the rise.
Okay. Well, my last question for you, Maureen, it's a tough one, but there's many pitfalls out there for tax sale investors. And one of the biggest myths that is not true is that this is a perfectly safe investment. There's many pitfalls. So, what would be the biggest pitfall in Ohio that you think investors or potential investors should look out for?
Well, I know I mentioned the importance of having an REO strategy. So whatever that may be, you really probably need to be thinking about that, when you're looking at your bid, and because you could end up with quite a bit of properties that will be your properties, which have to be tended to and can be fined for, as you mentioned, not cutting your grass, not bringing garbage cans in, a gutter, whatnot. So you definitely want to, be aware. There are actually several cities in Ohio that are requiring registrations. So in terms of, is your property vacant? Are you foreclosing? Is that applicable to a tax certificate holder? It's another way for a municipality to raise revenue and to, in their eyes, keep an eye on the housing stock. So that's, another area that seems to be a hot topic lately. What's required? Are the fees getting to be too much? That sort of thing. So that's something I would say is definitely a hot area. And also the servicing requirements. So as we said, the market in Ohio is heating up. The counties have more bargaining power, and so they want to partner with a group that can, certainly handle the needs of that county's taxpayers. So it seems to me that the RFPs and the treasurers are very interested in the servicing aspects. Do you have a dedicated telephone line you've got someone available during business hours? Can you get me a current payoff in 24 to 48 hours? Can you are you willing to respond to inquiries, that sort of thing? Because it's going to be a multi-year relationship with the purchaser, given the life of the tax certificate and the 1-year redemption period in Ohio. So they want to make sure they have a good partner. Your reputation is important because hopefully you are going to be buying in multiple counties. So you want to make a good impression with the county treasurer or treasurers that you're working with. So those are kind of the two that I flag myself when talking with clients about that.
Excellent. Appreciate it. Boy, I learned an immense amount today. Never even heard of the PSO sale route until today. So I appreciate it very much. For everybody, again, Maureen, excellent white paper. It's mostly dedicated on the foreclosure process, but if you want it in more detail, you can download that as well. And then Maureen, I think we'll be working on in the near future the prior to foreclosure sale white paper that we'll work with you on as well. So I appreciate it very much. Thanks for joining us again.
Yep. Thank you very much for your time.
All right. Thank you, everybody.